recording today. It will be posted on the Alabama Center for Dispute Resolution's website. And so if you're now joining us, we welcome you to the second of our four-part series on the collaborative practice of law. Today's topic is focus on team, breaking down roles. And at this time, I'd like to turn the presentation over to our panelists, Frances Nolan and Virginia Miller.
Good afternoon, everybody. This is Frances Nolan.
Hey, everybody. Good afternoon. This is Virginia Miller. Glad to have you with us today.
We're both lawyers, and we both have had extensive training in collaborative law. Just for those of you who have not joined us in our initial presentation, we wanted to just give a brief synopsis of what collaborative law is and what it isn't. It is not kumbaya, guru, hoodoo practice. It is a very structured and formal process that is voluntary, requires the consent of both parties, working with collaboratively trained lawyers, engaging a team of professionals, including lawyers, mental health, and financial professionals, to work with the parties to reach an agreement. The cornerstone of collaborative is that the lawyers and their clients contract from the start that the lawyer's representation will be a limited scope representation in which they will represent the client for settlement purposes only and not for litigation. The intention is to keep everyone's eye on the same goal, which is negotiated resolution, and to prevent use of tactics routinely employed in the litigation paradigm to extract settlement from parties. Collaborative is not positional bargaining. Collaborative is meant to be focused on interests and goals of the parties, and is designed to build outcomes around the parties' goals and interests. Today, we are here to discuss what does it mean for us to work as a team? What are the roles of the team members? And also, I guess, I can't see what slide you're on, Eileen, but we would be, I think, at this point on slide 7. How does your role in collaborative practice differ from your role in litigation?
And we are getting there right now.
Awesome. And I'm gonna let you take it, Virginia, and we'll just chime in and be collaborative in our approach to this presentation. And y'all, please do jot down your questions because we'll look forward to answering those.
The first thing I'd like to say about how my role as a litigator differ, or how does your role in collaborative practice differ from my role in litigation? Number one, initially, it's a huge paradigm shift from going from the traditional litigation role into being a collaborative practitioner. I did not think it was going to be difficult for me, but it is difficult for me, even though I think I'm not somebody who I would consider a traditional hardcore litigator. Making the paradigm shift is very difficult because you have a tendency and I think, just to go back a little bit, last time we talked about the collaborative team meetings when you're present with your client and the other lawyer and the mental health professional, potentially mental health professional is there, and or the financial neutral is there, and maybe the other lawyer unintentionally or intentionally triggers you. You really have to practice not going into that traditional reactive litigator mode. And a lot of times, and I'm going to sort of cross-pollinate here, a lot of times that's why the coach can be present, because the coach or the mental health, we call them coaches, but they're mental health professionals, when they are present, they sometimes will hear that trigger, or the financial neutral. I got to thinking about it actually, and I'm kind of going down a trail here a little bit, but I got to thinking about it actually that I think everybody likes the financial neutral the most. Because
they're neutral.
Well, because even the mental health professionals usually are, that they're positional in
a
their
little bit,
a little bit in their traditional roles. They have a tendency to side with their patient. We have a tendency to side with our client.
Yeah.
And so I think I got to thinking about that one day. I was like, I think that's why they like, because the financial neutral is usually always neutral. I mean, for the most part. And so,
I think one of the biggest shifts from litigator to collaborator is that your thinking is needing to be oriented toward how do we de-escalate conflict and increase the stability of communication between the parties. So reactivity is the enemy, whereas I think in litigation, reactivity is just the modus operandi.
Right.
I take what my client says, I react and accuse, and then there are counter accusations. And instead, we're trying to find alternate views and perspectives to gain insight that will take the focus away from the conflict and onto the issues at hand for resolution. Lawyers in collaborative practice need to learn to be legal coaches as much as anything. Having to understand how to be self-aware, how to practice empathy with our clients, while also remembering that there's another side to every story and trying not to view every action through the most negative filter. A perfect example that I come up with is that in a couple where the husband has always taken the trash out, and that has always been viewed as his job and a good thing. Sometimes when a divorce is pending, all of a sudden the fact that the husband is taking the trash out is suddenly viewed as him trying to cover up what he has thrown away in the garbage. That he's hiding his affair, or he's hiding his drinking, or he's hiding whatever. It's like all of a sudden behavior that has been routine and consistent takes on a new shape, form, and interpretation. And that's the kind of stuff that we're trying to identify and ratchet down to create, some sort of calmer perception of the situation. Would that be a fair?
I think that's an accurate.
And that may be a pretty extreme example, but everybody has experienced those sort of jumping to conclusion realities that exist between people who are divorced or divorcing. I think the other thing that I find most freeing is that we don't do formal discovery.
Right.
So we don't play the role of the drafter of discovery, and in many cases, we don't even have to be the disseminator of what it means and how it stacks up. That's the financial neutral job for the most part. They tell the clients together what information is needed to address the issues at hand, and those things are produced voluntarily to the financial advisor who, for the most part, assimilates that stuff.
Right.
To me, that's the best thing about collaborative. I mean, is there a lawyer alive who actually enjoys discovery?
No lawyer likes to draft or respond to it in particular.
Yeah, and so you're not duplicating effort.
Right.
Yeah.
Right. And also even if the financial neutral has not asked for something, if you are in a meeting, you determine that there are some documents or something that is needed, one lawyer in front of the other lawyer and both parties asks for it, and then it's determined whether that can be obtained or not. And you resolve it at the table right then. If they cannot obtain it, who could obtain it? Who does have it? The best way to go about it, rather than issuing discovery and issuing subpoenas and filing motions for sanctions. None of that happens, because if one party just absolutely refuses to produce, then that might
something that's relevant to the dispute,
right.
then that would probably stop the collaborative process, because our goal is to be transparent. Our goal is to be transparent with regard to absolutely any and everything that is vital and relevant to the resolution of issues in the case.
Right.
So if you have someone who is determined to hide their bonus check for whatever reason, this is not the process for them. However, litigation is probably not the process for them either, because subpoena power will put a stop to that secret in a heartbeat. The other biggest difference, I think, is that the lawyers will talk law to the clients together in the same room. And anybody who's practiced law for a while knows that you ask two lawyers the same legal question based on the same set of facts, and you're going to get two different responses. And so we transparently let the client see that. It's helpful, I think, to the clients to hear from two lawyers about perspectives about how the law applies to the facts in their case, because then there's not going to be this trying to use what my lawyer told me to threaten or intimidate the other party based on, claims or positions in the law. And really, we're only going to do that if the client asks us to do it.
That's right, because we're not confined by the law in the sense that you only get half of this or up to this amount of this and that type of thing. You can do whatever you want to do as long as it's not contrary to the law in some way, or illegal, just something outside the bounds of the law that just can't be done.
Like you can't not provide for the support of children
or something like that.
But the goal is to focus outcomes on the interests and goals of the parties, not necessarily on the bounds or application of the law. But to the extent that it is a legal process, and to the extent that clients want to be educated about the application of law to their facts, then we obviously are obligated to share that with them. And doing it in a transparent forum is, that's part of the shift. That's the collaborative shift. It's actually freeing.
It is very freeing. The other thing that I've enjoyed in the collaborative process is assisting the parties to be their best and highest selves. And I've done that. For an example, I've had a client before who sometimes would not look at his wife while we were negotiating. I would ask him to please turn his chair around, please look her in the eye. Things like that when I say making the paradigm shift, to kind of bring it back around to what I was talking about to start with, about why it was hard. That was hard for me, though, to instruct him in front of the other lawyer and in front of the opposing party, because you feel like you're getting on to them in a certain way. Sometimes the coaches may direct them to do things like that too. If the lawyer is taking notes or not paying attention, or what, not paying attention, but not looking at their client and maybe seeing what their physical reaction or what they're doing, or if they're staring into space. And I've asked my client to please look at the other party when she was speaking, because it was a moment in particular that I thought was pretty important to the process, when somebody was really had gotten down to their real interest and sort of their fears, and they were making themselves vulnerable.
Well, I mean, probably even in a litigated case, it's not your goal to intimidate or threaten or to be menacing in some way to the opposing party.
No.
But how would you describe the way that you believe you are obligated to respond to the other party in a collaborative context?
How would I describe that? I don't know, Frances. How would you
Certainly
describe? I don't know if I've got words. I don't know if I have words for it.
Open. You're not there to be a threat to them.
Oh no, you're not there to discount them and try to, what we said on the slide, disprove what they're saying or discount them in some manner. You're there to be open to it, listen to it, and then allow your own client to respond in an appropriate and high-level manner.
Right. I mean, one of the tricks of the trade is to give each party an opportunity to speak, make them remain quiet while the other is speaking, and then ask them to repeat what they heard before they respond to it. And that is sort of a practice that helps keep everybody on track. I actually had two things I wanted to say. I'm afraid I'm going to forget one of them, but it's so different. It's one of the things you have to prepare your client for. Like, you need to understand that there may come a point in time where you feel like I'm on the other party's side just because I'm being nice to them at a time when you're feeling frustrated with them. And that's all in service of your goal to reach a negotiated outcome. It's not a fact. It won't be the truth. It's not that I'm changing sides. Right. It's that my duty to you as your collaborative advocate is to help you achieve an amicable outcome. And sometimes that means being nice to someone when you're mad at them. And the other thing that I wanted to say is that one of the things I've noticed in just traditional practice is that parties can sometimes act better when they're face-to-face with each other and be less contentious and go off on fewer rabbit trails because they're looking each other in the eye and they know what each other knows.
Right. They know that the other one knows what the truth is, whereas your truth has been filtered somewhat.
Right. So when you're just like one-on-one, party to lawyer, I can tell my story and I can fill it up with all the facts I want to stack the cards in my favor and make the other person look terrible. But when I'm looking them in the eye, I'm not doing all that because that's just for show. Right. And so I think that that's something that all lawyers, traditional lawyers, collaborative lawyers have to remember is that sometimes you're getting a very exaggerated version of the story when it's just you and your client. And that's something we get to avoid in this collaborative process. And it's also something that can eat up an enormous amount of our time and energy in ways that we don't necessarily see as being our job as a lawyer. It's muddling through all that emotional crap, that just wears you out. Sometimes you just cut that off at its knees because people aren't going to dish that stuff out when they're face to face with each other. So that's another sort of refreshing reality.
The other thing I wanted to ask you, Francis, and I think this has been our experience, do you think the other members of the team see the lawyer as sort of, for lack of a better word, the captain of the team, so to speak, that they sort of give us a lot of deference or?
Probably more than they should. I think that's something that, when you have teams that have worked together for a while, you get past. But yeah, I do think, mental health professionals have conveyed to us that they find lawyers intimidating.
Right.
And that's really not our goal or our job in this process. So I think, Eileen, we can probably advance to the next screen. What are the pitfalls of collaborative practice? You with us? Eileen?
Yes, we've advanced to the next slide.
Yeah,
I had
okay,
you muted.
good.
I had me muted. Sorry.
Oh, okay. Thanks, Eileen. So what are the pitfalls, Virginia?
I think that a lot of what Francis started off with about this isn't any hoodoo guru type work. This is hard work. It can be hard as we think litigation is, but just in a different way. There's no fallback to the trial, as the slide says, to resolve the dispute. It's a matter of getting in there, working with the team members, getting called out sometimes. That can be difficult too, when a lot of times after we have a team meeting, we have a follow-up meeting, maybe without the clients or the parties. And I have been called out before, and not in a judgmental way, in a kind and diplomatic way, but you've got to be prepared to take a little constructive criticism if the other lawyer or the coaches potentially maybe see you aligning with your client in some way, becoming positional. That's going to be worked through and talked about, because otherwise, if it's not addressed immediately, you're going to continue to align with your client, and your client's going to want you to get pulled with them onto an island, which is going to ruin the dynamics of the team and maybe derail the process. And so that's what it's all about, is trying to maintain.
Yeah, the balance of being aligned with your client in the sense of wanting to assist in the achievement of the goals that they state, but not necessarily aligned with them in their emotional pathology of the moment.
Right.
It's being able to discern the difference between what is their emotional reaction and what are the actual facts relevant to the process at hand.
The next bullet point on the slide, when it says reminding the parties why they chose this path. some of that too. Sometimes the parties will start doing things that are contrary to the participation agreement. They're going outside of the process and going offline, meaning we try to keep all the conversations that we can in the process, either meaning in the meetings, or sometimes the lawyers and the other professionals, the team members will have some phone conversations and that type of thing. But we ask the parties to try to keep all the conversations within the context of those meetings. And sometimes they'll go offline. I certainly know I've had a client that's done that. And what it does is it slows the process down, because you've got somebody trying to work a side deal almost.
Well, then you get back into that old traditional paradigm where your client calls you and says, he said blah, blah, blah. And then you're supposed to call the other lawyer and say, he said blah, blah, blah. And then that lawyer talks to their client. We're trying to get out of that. We want it all to happen at the table with everybody present, witnesses, parties eyeball to eyeball, and that cuts down on everybody's stress. It expedites the process, keeps us focused on the goals and interests.
Right.
It's hard, and that is really hard at the beginning of the process until people start to understand and maybe get their first bill that reflects the cost to them in dollars of this kind of derailment crap that happens. And then they start to get the picture. You know, I guess the thing that we didn't say is it's a paradigm shift for everybody. It's a paradigm shift for the clients, paradigm shift for the lawyers, paradigm shift for the mental health people. And to the extent that the financial person is acting as a neutral and they aren't used to that, it's a paradigm shift for them.
Right.
So it's, you know, a lot of the work at the beginning is just educating the client about what is and isn't appropriate in this process and how to conduct themselves. And so there's a lot of sort of reminding. And of course, you're not reminding in the sense of holding someone captive in a process that they decide that is not right for them.
No, absolutely not. That's contrary to this being a voluntary process. What I meant by that is you pull out the participation agreement again. Sometimes you might pull out the participation agreement as a whole group and remind everybody what they signed. So everybody has a little bit of a refresher. And Francis talking about the speed of the case, how these offline negotiation, phone calls, meetings between the parties can derail. Then all of a sudden you've got to spend a lot of time that slows the process down. You know, a lot of times people are wanting to get through whatever their court case is, or, you know, their adversary or dispute, whatever their dispute is, as quickly as possible. And so, you know, it just slows things down.
So that doesn't serve their stated goal of getting through the process.
And so part of, you know, the parties dictating the speed also goes back to what Francis was saying with regard to discovery. If we have a meeting on October the 1st and we look at somebody who maybe has, you know, one party may have the information, and we say, how long is it going to take you? And they say 2 weeks. And we say, are you sure? And they say yes. Then we're like, okay. And so when do we want to have another meeting? Okay, within 3 weeks. You get it to us within 2 weeks. The financial person or the lawyers or whoever looks at it, have our meeting. But if you don't have the document,
you can't proceed.
We can't proceed, and we will cancel that meeting if the financial neutral or the lawyers haven't had time to review the documents, or the financial neutral hasn't had time to review the documents and discuss same with the lawyers on a team
as needed, whatever's needed.
Needed. And so their frustration it puts it back on the parties a little bit. It's not them waiting on you, which is sometimes how it can be in a litigated process. It's waiting on them to get their documents and whatnot together.
I notice you have to avoid transference and counter-transference of the parties' issues to the team members. And that sounds probably strange to any lawyer out there who hasn't really interfaced with the mental health world very much. And that's, you know, kind of something that is the benefit to having mental health professionals on your team. But if many of you are divorce lawyers, you probably know what this is by experience, even if you've not named it or claimed it. But it involves the taking on of other people's emotional or behavioral pathology. And to the extent that you lose your own objectivity and your own ability to assist in a professional and objective way. And so I guess it goes without saying then that working collaboratively effectively requires self-awareness, and it also requires the ability to maintain good boundaries, to be able to empathize with a client without taking on their baggage.
Right.
And hear them and have them feel heard without taking on their point of view to the exclusion of someone else's point of view.
And that's some of what the coaches and the mental health professionals' role is, and part of this. The mental health professionals / coaches will have meetings with the parties, sometimes all together.
Without lawyers.
Without lawyers. Sometimes maybe if it's a two-coach model, they may have individual meetings with their particular one party, their client, so to speak. And sometimes they'll all meet together to help them process some of this so that some of that doesn't happen.
Yeah. So we've mentioned a couple of things that I just want to clarify. A participation agreement. Participation agreement is kind of the cornerstone of the process. It is the contractual obligation between the parties and the lawyers regarding the rules of engagement, the process, how it works, and what's expected of the parties and the lawyers in the process. It is lengthy. I have shared a standard participation agreement with Eileen, and I think we have one of those that we can distribute to people. It's hard to understand it until you've seen it for yourself and read it. It is very comprehensive, and it is something that at the beginning of the case, lawyers and parties sit down and review in detail, because it's a paradigm shift for everybody. These are sort of the rules of this paradigm shift, and so we want to make sure that people are aware of it, understand it, ask questions, flush it out, and then we refer to that as needed throughout the process to kind of keep everybody on the track. And then the other thing we talked about are the different models. So I guess we're about to morph into discussion of the different roles. Sure. So we have lawyers, we have mental health, we have financial, and there are different models that exist in the employment of collaborative practice. There can be a one coach model, which means that there is one mental health professional acting as a coach to both parties, so they become a neutral. They don't take sides, they don't have sides, they hear everybody, they try to negotiate between the parties to help them hear and be heard. And we've used that model. Sometimes it's most effective. Sometimes it just works better. It just depends. The other model is to have two mental health professionals, one for each party. So then it would be one lawyer for each party, one coach for each party, and then one financial neutral. So that, again, the team could be two lawyers, one coach, one financial, two lawyers, two coaches, one financial. And then you could also have a third mental health professional if needed to act as the child specialist or the voice of the children in the process. In the cases I've done, we've only had a child specialist like maybe once or twice.
But there's always two lawyers, right, Francis?
There's always two lawyers. That is the biggest misconception of the public. I don't know that lawyers misunderstand that, because lawyers understand that parties to any legal dispute, their interests are adverse. You can't represent them both. But the public seems to think that if you're calling it collaborative, that should mean one lawyer is representing both parties, which, terrifying to think that that's what people would believe. Yeah.
And different areas of and I can't remember now, but we've had some folks come and train us before, and I think, was it the mental health professional from Canada did they do a one coach model in Toronto, or did they do two coach models, and she thought it was strange to do a one coach model?
I think, I can't remember, but different jurisdictions do it different way. Like Texas, one coach. Florida, one coach. California, two coaches.
Yeah.
Canada, collaborative is sort of the standard of practice in divorce in Canada. And I think depending on the region, they probably have one coach or two coach.
and
we'd like to just do what the case seems to require
and feel like was necessary at the time,
Yeah.
based off of the circumstances. But and just to follow up real quick, a statistic, I haven't looked at it in a long time, but I remember reading an article in Canada. There's a town in Canada, I think it's Medicine Hat maybe, that is, they can do litigated divorces, but they have just come to do only collaborative.
I want to live there. Man, I'm just telling you.
That's the only way they do it there. So anyway.
So one misconception is that the mental health people are counselors in the collaborative process, and they are not. This is not a traditional counseling role. They are not deciding what's wrong with people. They are not treating any mental health problem. They are coaching the parties through a bumpy part of their life to try to assist them in having very difficult conversations in a productive way. I think we touched on this, but collaborative is forward-looking, where litigation is backward-looking. So in litigated divorce, we are recreating the story of the marriage to present the facts to the judge in a way that we hope will help the judge to think that our client deserves more than the other client in terms of, custody or assets or whatever. That's not the deal in collaborative. We're going to hear their stories because people need to tell their stories as part of the grief process, but we aren't focused on that. We are not going to ask them to relive absolutely every painful, horrible part of their marriage story. We are here to ask them, what do you want your future to look like? If they have children particularly, it's really important to help them understand they're writing their children's divorce story. How do you want it to read? What do you want this to look like on the other side? One of my favorite trainings, one of the trainers said that they like to ask the client, pretend that I ran into you in the grocery store 2 years from now and you were so happy, and I asked you, what does your life look like now? What would you tell me? Dream big. Tell me what you want it to look like. And helping people to sort of shift their focus from woe is me and it was all awful and I'm a victim to, hey, I can be the author of my next chapter. How am I gonna let it read? Can be freeing to the client and help them to kind of move from their pain into, decent decision making.
The other thing I just want to add real quick, and I may have already touched on it a little bit, is the coaches sometimes help the lawyers too with being able to.
Sometimes, like all the time.
Sometimes you may have triggered each other in some way that then makes you shift, like I was stating before, back into more of a positional type role, and the coaches need to help the lawyers be able to find their words, so to speak.
I mean, everybody who's practiced law for a while has represented somebody that was really hard to deal with, right?
Yes.
And that's going to happen in collaborative. It's going to happen in every paradigm. And so it is incredibly freeing to have someone that you can pick up the phone and call and say, I am at my wit's end. The client is not listening. They're exaggerating or whatever it is that's happening. Help me. I'm losing my mind here. And then all of a sudden you have this skilled person who can sort of walk you through maybe how to get to a better place with the client, or better yet, take the wheel with the client and kind of navigate the client to a better space. I mean, practicing law and divorce, particularly in contentious, high conflict, contentious divorce, is a lonely, horrible job. I hate it.
It's isolating.
It's very isolating.
Very isolating. But you touched on something I think maybe the folks on the phone might want to know about that you just said. You called the coach and you said, this client is not listening and they're exaggerating. what gives you the ability to share that with the coach?
The participation agreement.
Okay.
Goes back to the contracts that structure the process. What the parties have to understand at the outset is that within the team, we are a closed cell of confidentiality. We don't share anything that happens in the team outside the team. But for the process to succeed, we have to have transparency between professionals. And so because we're still lawyers and because we still have a duty of confidentiality to our clients, they need to understand that they are waiving that. And we also have to articulate to them that they have the right to tell us, okay, hold up, I need to have a confidential conversation with you and I don't want you to share this with anybody. And assuming that you do that and in that conversation there is nothing that is vital or relevant to the conflict that has to be shared, you do that just like you would in any context. But to the extent that they reveal to you, I'm pregnant by another man's baby, or I just got a $400,000 raise, or anything like that, then you are at a crossroad because you can't go forward in the process and uphold your legal, ethical duty to the process and your confidentiality duty to the client. So you give the client a choice. You say, I can work with you and I can help you to produce this information in a context that maybe will be most helpful, or we can terminate the process. But those are your choices.
And that might be a time to call a coach in as well.
That might be.
To help everybody find their words.
But of course, you can't do it if you've been
true.
asked not to share.
That's true.
So that might be the first thing you ask permission to do is say, can we bring the coach in to talk about this? The coach would be bound by the same sort of level of confidentiality unless it's one neutral coach.
Right.
But that can be, some of the hardest work that you do. Frankly, though, I'm trying to think if that's ever happened to me in 25 or 6 collaborative cases. I don't think that's ever happened. I don't think anybody has asked me to keep a secret that I couldn't keep.
Right.
So you'd think it would happen more, I guess, but it doesn't. I mean, some of these cases are going to be selected out by the introduction process.
Yeah.
We are obligated under the law in Alabama that adopted the Uniform Collaborative Law Act to educate our clients at the outset about all of their options for resolution and to tell them the pros and cons of each and to give them the choice. So they need to have understood going in what things they're relinquishing. Don't have subpoena power. You're giving me license to be transparent with all the professionals on the team. And you're committing to being transparent about all information that is relevant to the dispute.
Talking a little bit about, we haven't talked much about the financial neutral, but what do you see sometimes? I think in the past maybe we've seen with the financial neutral, maybe their hardest job is when you have one party that has a lot of power and information regarding the finances and the other party does not have as much knowledge, understanding, confidence in the finances.
And that's pretty common, wouldn't you say?
I think it is pretty common, but I wanted to touch on that because.
So, yeah, in that situation, there have been times when I call it the knower, the person who knows everything.
Right.
Doesn't want to waste their time in meetings educating the non-knower about what the information is. And so the financial neutral can get permission from the knower
to meet
individually with the unknower and educate them. But nothing in that meeting would be confidential.
Right.
There would have to be transparency about what went down in that meeting. But that has happened. And usually that's something that people welcome because they don't want to.
Well, they feel empowered to some extent. And they gain confidence at that point, which I think probably makes the process a little more successful.
Oh, it does.
It may build some trust at that point.
I think one of the best things about collaborative is its ability to rebalance imbalances of power. Because imbalances of power create conflict in and of themselves. Being a dependent spouse who doesn't know what you have makes you inherently suspicious, distrusting, and can create conflict from the outset that the person who knows everything never even intended to create.
Right.
And so to the extent that we can rebalance that power by making, the financial neutral empowers the dependent spouse to know what there is to know from a neutral voice that can be trusted, not to have a stake in spinning it in one direction or the other, then that can tamp down a lot of conflict that somehow is just generated sort of on its own.
Right. Well, but we do have to be careful, though, as practitioners, because sometimes these folks who are the knowers, sometimes they choose this process because I think sometimes they think that's how they're going to continue to maintain some of their power and maybe keep the unknower unknowing, so to speak.
The narcissist love collaborative.
Right, and so we have to be careful as practitioners, because sometimes they can slip by in the beginning. Yeah,
and that I think that can be one of the beginning challenges. Just getting the process started. We call it launching the collaborative process. Launching the collaborative process is usually the most stressful part. And so when you have that person who's either a narcissist and thinks they're going to control everything, or just knows everything and has already decided how it needs to end, you really, really have to work with them to help them to understand that they aren't driving the train and that they're just going to have to suck it up, pump the brakes, and give it a minute because somebody's got to catch up with them. And that's just going to be the way it is. And it's going to be the way it is, y'all be honest, no matter what process you choose.
Right. No, that's true. I just wanted to mention that because I know that sometimes the knower, the knower who wants to continue being the only knower, that's the process. Yeah. The other thing I think we may have skipped over is how do we, obviously the parties come to and find a collaborative lawyer. I think we've talked about that a little bit before. But how do we choose the coaches and the financials? How is that? Yeah. How does that happen?
I guess it's, we try to base it on their temperaments and their needs, right?
But do we have do you think normally there's a meeting that occurs first where the lawyers and the parties decide at the initial meeting, or does that kind of happen pre-initial meeting? Or
usually in the cases I've done, what happens is I'm hired, the other collaborative lawyer's hired, so one of us picks up the phone to call the other, and we have an initial discussion of the issues and the dynamic between the parties, and float around names and ideas about team members, come to a consensus, call those people, ask if they're available, give their names to the client, let the client meet them, make sure they vet them and they're cool with them, and thereby the team becomes assembled in that process. Yeah.
I just thought maybe, I think we might have, I don't know if we talked about
we probably did skip that.
But we might have skipped that part, and I'm sure I was thinking, how do the other people become involved? And I don't think we talked about that. In our first webinar.
I guess the only other thing that I just wanted to touch on before we open it up for questions is that the financial neutral can be a dual role person in the sense that if there's a business to value, they can be the neutral business valuator if they're skilled and trained to do so on top of their role as the neutral in the other context. Or you could have two neutral financials if you needed someone with more of a CFP background to be the financial neutral in general, and you needed the forensic to do the valuation. And I've had cases where they were done both ways. But then things like real estate appraisals and, that kind of stuff is pretty much just conducted the way it always is. Right. If people want to, to the extent that we can, we try to just do one of everything. Get the parties to agree to an appraiser and have properties appraised if we need values.
So we don't duplicate costs.
Yeah. So
duplicate efforts and duplicate everything that we duplicate when we're in mainstream litigation.
Yeah. And then to the extent that, God forbid, a process would fail, what information that's been produced inside of this closed cell could then be replicated or accessed in the litigation paradigm? Well, nothing from confidential meetings.
Right.
But obviously, if you've gotten an appraisal, that's obtainable. If you've exchanged bank records, you're still going to get bank records.
Right.
Anything that is, documentable and not of a confidential nature is still going to be accessible. But none of us can be called as witnesses, and none of our meeting minutes or anything like that are going to be subject to discovery or to use for impeachment of a witness on the stand or anything like that.
And all of that is in the participation agreement.
That's right.
That's why it's so long and comprehensive, so that everybody understands.
That's right. So do you think of anything else before we open it up for questions?
No, I don't think so. I think it's about time for us to just open it up. And
yeah, I got 12:50 on my clock. So do we have any questions, Eileen?
Well, at this point, we don't have any questions, but I've just unmuted all the microphones. So if you have a question for the panelists, if you'll just please state your name and what your question is, and we welcome any questions at this time. Okay, at this time, there are no questions. Ladies, I did want to ask you, if somebody is interested in getting training to become a collaborative practitioner, I'm going to your slides that talks about where I can get more training. And so could you talk about that?
Well, Collaborative has an organization called the International Academy of Collaborative Professionals. Their office is in Phoenix, Arizona, and they conduct trainings, and that is a great website resource, www.collaborativepractice.com. There's also a group in Virginia, Collaborative Practice Training Institute. They have trainers that we've actually brought down to Alabama to conduct trainings in the past. And
IACP too. That last training we did.
We've brought IACP trainers here, and we've had CPTI trainers here. Both are great groups and organizations. We haven't conducted a training in Alabama in a long time because we just haven't had the critical mass of people to, be able to cover the cost of it.
Our last one was what, February 18th?
Yeah, and before that, it has been several years.
It's been like 2 or 3 years.
Yeah.
But I think one thing Eileen, thank you for asking that question. I think Francis has touched on this in our first webinar. So for everyone who wasn't on the first webinar, this is not a CLE like Francis said, where you go and you can just kind of sit there and read your newspaper and do the other work and pay attention and get the handout. It's going to be a training where very hands-on, broken into small groups. You will be trained usually with mental health professionals, financial neutrals, and the lawyers, so that everybody can kind of get a feel when you're broken into the small groups of what it's going to be like to be in a team. You work through real life problems, and then afterwards get back together as a big group, and the trainers go through it one by one, and they walk around during the process and help you kind of you're stuck or where you are when people, just understanding the initial steps of what they're doing.
So it does require your full attention. It's not a go play golf CLE. It's a commit all the time that the training requires to actually learn it, and don't expect to learn it in one training. Usually, I don't think I even had a clue what I was doing until I had about 3.
Right. I think, that last training, I think even though I'd done collaborative cases, I was like, I think I might be getting it.
Yeah. You learn stuff every time you go. You can never have too much training. And I think that's also sort of a paradigm shift for lawyers, because we're sort of used to doing what we know, and the idea that we have to start all over at the beginning and learn something all brand new that's really going to challenge us and make us sort of doubt ourselves.
Right.
Like having to be a baby lawyer again, it kind of stinks. I mean, it was nerve-wracking, but it's worth it. It's really a good skill set, and I find that I employ it in every aspect of my life.
I do too. After all the trainings, and every time I go to a training and then I start employing it even more, I take what I've learned and employ it even more into my life. It's changed the way I practice law, even in litigated cases.
Mhm.
And I think, and Francis has said this, and I believe this, I feel like we as collaborative practitioners here in the Jefferson County metro, Shelby County area have changed the way that divorce practice is
Well,
done.
we've certainly made it more acceptable to involve mental health professionals
Right.
in the resolution of disputes and management of conflict.
Right.
And to that extent, it's made life better for everybody, I hope.
And we have here at the Birmingham Bar Association, we have a collaborative law committee. We also have the Birmingham Collaborative Alliance. The BBA Collaborative Law Committee is obviously just made up of lawyers because the Birmingham Bar Association is only lawyers, as it probably should be. But the Birmingham Collaborative Alliance is made up of financial neutrals, the mental health professionals, as well as the lawyers.
And Virginia's the president
of the Birmingham Collaborative Alliance.
Yeah.
And this year, the chair of the Collaborative Law Committee.
You're the honcho of everything.
I'm not the honcho.
Did anybody have any questions while we were yabbering on about that? Well, I don't know if that means this was just dull as dirt or
we just did a
answered all their questions.
Job. We did such a fantastic job. I think that's what we answered everybody's questions already.
I hope so.
I think we have a question coming on.
Okay.
And maybe we don't have a question. I just heard someone speak. And so, ladies, I think we're at the end of our time. For all of you who are on the call, they prepared a nice reference list and resource list for you and the PowerPoint presentation. We have up on the slide their contact information. If should you have any further questions, you can communicate with them directly. And at this time, we'd like to thank Francis and Virginia for a great program. And it was very informative and enjoyable. And I invite everyone to visit the Alabama Center for Dispute Resolution website and Facebook pages for more training opportunities. Our next webinar is set for October 18th, where the discussion will continue with the how-tos of collaborative law. And we hope that your schedule will allow you to join us. Please remember to complete your program evaluation on SurveyMonkey. Here is the code that you will want to enter into your survey. It is 4205. That code again is 4205. Please enter it in the SurveyMonkey evaluation. And the recording of today's webinar will be posted on the center's website. And thank you all again for attending. And this will conclude our webinar. Thank you.
Thanks, Arlene. Thanks, everybody.